Hearing regarding, I think, Mr. Price to order. And just for expediency, anyone, I'll go ahead and swear in all three all three code enforcement. I assume you all aren't going to testify, but I'll go ahead and swear in Mr. Price and three code enforcement officers at the same time would seem to be the most expedient way. So if you all four would raise your right hand. Just repeat after me and say, I swear the evidence I shall give shall be the truth, the whole truth, and nothing but the truth. Okay. Thank you. And I think, Mr. Hartley, would you like to proceed?
Yes, thank you. I'd like to call Dusty Carter to the stand, please.
Dusty Carter. Mr. Carter, I'm sure you recall that you're under oath.
Yes, ma'am.
Thank you.
Mr. Carter, could you state your name and position, please?
My name is William Carter. I'm a Chief Code Enforcement Officer for Georgetown, Scott County.
Thank you. I am going to hand you several documents, which I'll ask the hearing officer to mark as Exhibit 1. All four of these documents are separate, but if you want to mark them as 1 through 4, that's fine.
I will get to the marking them after we kind of get the foundation. Do you want to lay the foundation for what these are? And you need them back?
If you don't mind, I'm going to ask the witness. I will state that these were emailed to me by the Code Enforcement Office, and I believe they were taken out of the CityWorks system, which is City of Georgetown's new Code Enforcement Administration system. So if I could ask the witness if he recognizes these.
Yes, sir. These are citations that are formatted and processed through the CityWorks system that were issued to Mr. Price on 4 different properties that he's responsible for.
Were those taken through were those made through the regular course of business?
Yes, ma'am.
Regular business records?
Yes, ma'am.
Okay. Thank you. Mr. Price, do you have any objection to, can you hear okay?
Yes, ma'am.
Okay. Do you have any objection to these citations being entered into exhibits?
I'm seeing, 311 South Royal Springs Avenue. Okay, I see what they've done. They've divided one of these properties into 2, apparently. I mean, I thought there were only 3 properties. 312 Lexington Avenue, 311 South Royal Springs Avenue. I thought that 311 South Royal Springs Avenue was the same as, so they've divided the upper, what I call my upper hayfield, into 2 properties.
Okay, and Mr. Price, anything factual with it, you'll be able to bring up as maybe a reason to disregard one of the citations or not, you'll be able to present that as a defense. But as to just kind of the underlying citations, that these are correct and accurate copies of the citation you may have received, and that they were created during the regular course of business. Do you,
Yeah, I guess, you base the addresses on 4 different deeds, is that correct?
well now, Mr. Price, this is not your time to cross-examine. We'll get to that. As I said, we're not determining whether or not it was correct or not to issue these citations, just whether or not these are correct and true, accurate, correct and true copies of what you received as the citations.
Yeah, they're accurate, they're true
Okay.
copies of their
Okay,
citations.
so we'll enter these 4 as exhibits. Thank you. And Mr. Hartley, you may proceed.
I would like to ask the hearing officer to take judicial notice and mark this as Exhibit 5. I printed this morning from the website of the Property Valuation Administrator. This is a map that is simply highlight of those 4 properties listed in that citation.
Okay. And has Mr. Price been given a copy of this? Okay. And you're proffering this as your Exhibit 5?
Exhibit 5.
Okay. Mr. Price, do you have any objection to this, to the Exhibit 5 being offered?
No, so long as, I don't recall whether, I consider this 3 properties. I bought them as 3 properties. No, that's right. The upper property was bought in 2 parcels, so there must be 4 deeds, so no objection.
Okay, thank you. You may proceed, Mr. Hartley.
Witness, could you review that and tell me if those are the same 4 properties that are listed in the citation?
Yes, sir, I believe they are. There may be a breakdown, as Mr. Price said, of one of these sections into 2. One of the addresses is off of South Royal Springs, the other one is off of Lexington Avenue. One is off of 167 Rucker Avenue, the other is a landlocked GIS property that's listed off of Rucker Avenue. Is the way these 4 outlined are.
And are all 4 of those properties owned by Mr. Price?
Yes, sir, I believe they are.
Can you tell me what precipitated the issuance of these citations?
We received a complaint of overgrowth on this property from area neighbors.
Once again, I couldn't hear that, please.
We received a complaint of overgrowth of grass and weeds on these properties.
For simplicity, I'm going to just refer to all 4 of these as the property. They're all, I'd ask the hearing officer to take notice that all 4 of the properties are commonly owned and are adjacent to one another, so I'm just going to treat them as one property. I'm going to introduce another exhibit. And I'll state for the record that I printed these again out of the City Works system. I pulled these from case number 18-224, which is listed as 167 Rucker Avenue, and the date in the system for the photo is May the 1st.
Do you know who would have taken it or would have knowledge of what it may have looked like on that date?
I will ask the
Okay.
witness if he recognizes that. You take a look at that and tell me if you recognize that.
Yes, sir, this is a photograph of 167 Rucker Avenue from about 6 feet out in the street near the east corner of the property.
Do you have any reason to believe that was not taken on May the 1st, as the system indicates?
I believe it was, yes, sir, May 1st.
And you took that photo in the
Yes, sir, I
normal
took
course
this,
of your
I believe I
business?
took this photo.
Mr. Price, do you have any objections to the photo?
Well, I object to, yes, I object, because
On what basis?
under your ordinance your ordinance 16-009, this is managed vegetation, and managed vegetation does not warrant a citation saying that it cannot exceed 10
And
inches
Mr.
in
Price-
height.
Mr. Price, we'll get into any defense you may have later on, but basically, as to whether this can be entered as an exhibit, we need, Officer Carter has testified that he took that photo, and that is approximately what the property looked like on May 1st when he took that photo. So we're only getting into whether or not that is the property, and if it looked approximately like that on the date that it was taken. So any defense you may have as to the managed vegetation or something, you'll be able to present when it's your time to present your case. But as the fact that this is the correct property, that this property had this approximate appearance, that is only what we are considering as to whether or not to enter that into exhibit. But you will be able to present your defense as the managed vegetation. So do you?
This is the same property you sent me with the initial,
Mr. Price, please recall you're not making it's not time for cross-examination, so we're making arguments as to whether or not that is not the correct property, that it did not have that appearance on that date.
well, could you ask Code Officer Carter if this is the same photograph you sent me?
No, Mr. Price, that's not what we're not, as I said, we're looking at whether or not that's your property and if that had that appearance on that date. So I'm going to overrule your objection at this time and allow the pic.
I mean, I'm trying to think about it. I didn't object.
I understand you're objecting. I'm overruling it because, and you will have a chance to
Okay, well,
present.
all right.
You will have a chance to present the managed vegetation argument on your portion. So, Mr. Hartley, you may proceed. That is entered as number 6.
So, you mentioned I'm looking at 167 Rucker Avenue, approximately in the middle of the street, correct?
About 6 feet out in the street, yes, sir.
At 6 feet out, and this was a May the 1st photo. Does this photo, in your opinion, show rank untended vegetation?
As a whole, yes, sir.
I'm going to introduce another exhibit.
What was it? What was your comment there?
I asked him if in his opinion, if that photo showed rank untended vegetation.
He said yes, and you said what?
I said I was going to introduce another exhibit.
Thank you.
I will state for the record that the Code Enforcement Office emailed me this photo yesterday, and I believe they took this photo yesterday. I will ask the witness to verify that.
Go ahead. You can ask the questions first.
Yes, sir.
Did you take that?
I took this photo yesterday afternoon in the middle of a rainstorm. Yes, sir.
You took that photo?
This was taken from inside my vehicle, not outside standing on the street.
Is that photo essentially more or less from the same vantage point, or looking at the same property?
Yes, sir. You can determine that from the growth of the trees, same trunks, same locations.
And you took that photo in the normal course of your business?
Yes, sir, I did.
Mr. Price, do you have any objection to this photo?
These two photos are not from the same point. This photo, the more recent one, is taken from a point further east, which and includes a part of the neighbor's property here. This property here, this photograph here was taken up the street and does not, you can see for yourself. If they claim that this is, are you gonna?
I will stipulate to agree to what you're saying, that it is from slightly a different vantage point.
Right, but the fact is, the night before last, if you don't, this area right here is basically been weeded the night before last. I went through there and pulled out a lot of, but that doesn't show up on this, the same area does not appear in this photograph. The eastern end of the median is, I weeded night before last.
Okay.
I put because I anticipated I wanted to meet your approval. I went through there and pulled a whole bunch of weeds, but that is not verified by this second photograph or it's not. It is verified by the more recent photograph, but for comparison's sake, the same area does not appear in this photograph.
Okay, and Mr. Price, so you're saying that part of this photo shows up as your neighbor's. Is that the part with the fence, or what part is your neighbor's?
Yeah, that fence belongs to my neighbor.
Is that the only part that belongs to your neighbor?
You see the median there, it's mowed. That piece of fence you see there, that belongs to my neighbor.
Okay,
And my eastern boundary begins there
okay,
where it's not mowed, but I went through there and selected all weeds that have no economic value that I know of. And the plants that remain do have economic value.
and Mr. Price, I understand Mr. Hartley's stipulation, and I understand your contention about the neighbors, and I'll be happy to make a mark on there as to your neighbor's portion. I will only consider the portion of the picture that is your yard. I think that we've heard from Officer Carter that he had taken that photo, so I will admit this is number 7, but I do understand, and I don't think that it matters that they're taken from different vantage points. I mean, as long as it is substantially your property, which it is, and it's taken on the date, I don't think it matters that it's taken from a different vantage point. But I did make a mark on there as to show where your property ends and where, from what you're saying.
All right, well, the problem is that you can't compare the two photos if they don't include the same area. And they do not include the same
I
area.
won't necessarily use them for comparison.
Thank you.
Well, I would ask Mr. Carter to consider the portions of the property that are the same, and I would ask you to tell me so there's an approximate difference from May 1 to yesterday of a month and a half.
Definitely.
Okay, would you describe the second photo, the photo from yesterday, as more or less? You indicated that the first photo did, in your opinion, indicate rank untended vegetation. Do you think that since that time the property has become more or less tended?
It appears to have become, as a whole, less tended. There are sections where you can see things have been removed, and there's a pile of removed vegetation
That's right.
at the top of this, near the area where the fire hydrant is. The box has been removed that had
What was that last?
plants growing in it. And the first,
Boxes had been removed.
there's
Boxes had been removed.
What's been
it's
removed?
like a,
Mr.
it's-
Carter, I think he can't hear. Could you speak up? He left.
there's a box in the photograph exhibit number 6 that was out in the street from Mr. Price's property that had vegetation growing in it that appears to have been planted for future use. That box is not appearing in the second picture. It wasn't, I did not see it yesterday. But these are of the exact same property, not from the exact same spot. These are both photographs of the property at 167 Rucker Avenue taken from the street.
Thank you. I'm going to introduce, are we up to?
We're up to
7?
8.
8. I will state for the record that I also pulled this morning from the City Works system, case number 18227, which lists an address, a GIS address, it doesn't have a street address, of 167-10-255.000. And the pictures that were in that system were tagged as May 1. Can you tell me if you recognize that?
It's an exhibit, what, 7?
8.
Number 8.
8?
Number 8. Yes, so this photograph was taken May 1. This is standing on property at the end of South Royal Springs, right near a fire hydrant. You can see the top edge of the fire hydrant with the turn on, turn off valve at the top of it. Looking towards South Broadway, Garth School area, towards this landlocked section of GIS property. It does not have a specific address other than a GIS number.
You took that photograph on
Yes,
May
sir.
1?
I took this photograph.
Of course it did.
I took this photograph, yes, sir.
Okay. Mr. Price, do you have any objections to this photo?
No, ma'am. I mean, other than in the context of my overall objection to being cited.
I understand that objection, and you'll be able to present that defense, but this is a true and accurate representation of your property on May 1st.
I think this is the same picture he sent me, in black and white picture, I think he sent me on May 1st. That's all I can say.
I will enter this into exhibit as 8.
Thank you. If you would mind to pull up the PVA map I handed you earlier, and just, you could indicate which property that is.
On exhibit number 5, this photo was taken of the property looking at this that would be to the extreme right that is outlined in yellow.
So the parcel that's furthest to the east on that photo.
Yes, sir. The lay actually, if you turn upside down, is the way the property actually lays. And the photograph was taken from the edge of the pavement in the grass next to a fire hydrant that's covered by that yellow line, but would be immediately to the left if you were looking at it upside down.
Will you be able to write in the box?
Yes, ma'am.
Just, is that where?
Identify
just put 8, yeah, just put
as
8.
GIS.
You can put 8.
Or number
'cause
8.
Yeah. And Mr. Price, we are marking on the PVA number 8 for the exhibit photo on the PVA
Number 8.
photo. And that is the largest, it looks like the largest block of land. We're just putting a number 8.
That's exhibit 5, isn't it?
Yes, sir. I marked
Yeah.
on the exhibit number 5 to
Yes,
show
we
what
marked on
property that
exhibit
was.
5, so I want you to be aware of that.
So you're designating this largest parcel as the same as being photographed in exhibit 8?
That's
Is that right?
correct, yes.
Yes, sir. The majority of that, yes, sir.
So can you describe to me what I'm looking at in that photo there?
In this number 8, you're looking at a parcel that is surrounded by the houses on Ely Avenue to the east, houses on Rucker Avenue to the south. Property that Mr. Price owns to the west. And then homes on South Laurel Springs.
If you will reference the citation earlier, which is a citation that corresponds with 18-227.
227, yes, sir.
And I believe that would be labeled as exhibit.
Number 4. It's exhibit number 4.
In your opinion, does that photograph show, well, why don't you, if you wouldn't mind to read what the violation cited was there.
Case number 18-00227 states offense information is an inspection of the property revealed a violation of Georgetown Code of Ordinances Section 4-122, which incorporates International Property Maintenance Code, IPMC, Section 302.4, which prohibits the presence of untended rank or unmanaged vegetation. Long grass which exceeds 10 inches in height is deemed a violation of this section. An inspection of the property revealed a violation of Georgetown Code of Ordinances, Sections 4-121 and 4-122, which incorporate IPMC, which is International Property Maintenance Code, Section 302.4, and which prohibit the presence of untended rank or unmanaged vegetation.
In your opinion, does that photograph constitute evidence of that violation?
Yes, sir.
Thank you.
And which photograph are you looking at, please?
Photograph number 8.
Taken May the 1st.
This one was taken May the 1st, yes, sir.
And I thought we were dealing with violation case number 0224.
Mr. Price, remember, please recall, we're not at the time for you to cross-examine yet. Once Mr. Hartley rests his case, then you can cross-examine,
Excuse me.
or at least finishes with this witness.
And I asked the hearing officer to mark this as 9. This photo was sent to me by the Code Enforcement Office yesterday. Do you recognize this photograph?
Yes, sir.
And can you tell me what that photo is?
This is a photograph, not from the same vantage point, not from standing beside that fire hydrant, but from within the vehicle due to the rain.
Is this a photograph looking at the same parcel we've identified?
Yes, sir.
on the
This,
ZBA map?
this is the same parcel as identified as parcel number 8 on exhibit number 5,
And when did you take that photo?
yesterday afternoon.
And you took that in the course of your ordinary
Yes, sir.
business? Okay, thank you.
Mr. Price, understanding the limitations to the objection, and this is not a time to make a defense, do you have any objection to this photo being entered as exhibit number 9?
Not at all, because it shows clearly that I've mowed.
Okay. I will enter this as exhibit number 9.
So taking a look at those, recognizing that those two photographs again are separated in time by roughly a month and a half, and are looking generally at the same property, is the property that it shows in that second picture more or less overgrown?
It's more overgrown than the original picture taken on May the 1st.
I mean, how tall would you estimate the grass is in the early photograph?
Somewhere close to 18 inches to 2 feet tall.
And when you issued that citation, you would have taken measurements? Is that
Yes, sir.
correct? And approximately how tall would you say that grass vegetation is in the more recent photograph?
I'm 5'8" tall, and if I was to stand out in that, it would be at least up to my shoulders, if not taller.
Does, in your opinion, is what is growing on that property, is that all grass? Is it grass plus other plants?
I'm I'm not able to identify plant species the way Mr. Price is. There is some grass there. There's a lot of grass there. There are a lot of weeds, what I would refer to as weeds, which
Is it fair to say that there are numerous different species of plants?
absolutely fair to say that, yes. There are little saplings growing in there that tend to grow when things blow in there, or a bird drops a seed. It's just obviously overgrowth, unintended.
I would ask that this be marked as exhibit. I this morning downloaded this photograph from the CityWorks system from case number 18225, which lists an address of 311 South Royal Springs, and this photograph is dated in the system May 1st.
Sorry, I couldn't hear that. May 5 what?
May 1st. Do you recognize that photograph?
Yes, sir. This is a photograph of that fire hydrant I was speaking of. Not standing right next to it on top of it, but back from it where you can identify the fire hydrant itself, which gives a good reference as to the height of things in that area.
You're seeing that photograph, you're standing in relatively the same place as the other photograph. You're just simply facing a different direction.
Within 5 or 6 feet, yes, sir. I'm 5 or 6 feet further back from number 8, yes, sir.
And could you, if you don't mind, identify on that same PVA map which parcel that would, which parcel that is a picture of?
On exhibit number 5, standing at that location, this is looking at the rear section of a parcel of property, which would be addressed as probably South Royal Springs, adjacent to Lexington Avenue section. This is adjacent. This property is adjacent to the rear of 159 Rucker Avenue, and I'm not sure the number. A property belonging to a gentleman named Gant. That shows right straight where the telephone pole is growing would be the edge of Mr. Gant's property, and then the White House that you can see in the photograph of number 10 is the structure on 159 Rucker Avenue.
Thank you.
And Mr.
This
Price,
is sorry, is this exhibit 10?
it is. Do you
Yes,
have
sir.
any objection as to the the limited scope of, or is this your property and taken on that date? And obviously, we have testimony. The person took
I
it.
object in that this is a picture of the town's right-of-way on South Royal, an extension. The town has a right-of-way south of South Royal Spring Avenue. And I object to Code Officer Carter's description of the property, because everything to the right of that fire plug, it belongs to the town of Georgetown.
Okay, I'll be happy to make a note of that, but you do acknowledge, and I heard testimony that this is basically, I think, easier to say, the longer grass is your property. It was taken on May 1st by Officer Carter, so I will admit this as an exhibit. But I have made a note of where your property line is on the photo.
Yeah, well, if there's any tall grass there, it belongs to the town of Georgetown, not to me.
Are you saying your property, well, we'll get into, that is we'll be able to get into that when you are presenting your case on direct. And I'll ask you that question then.
But
Number 10, and could you please mark on that PVA thank you.
I'll introduce this as Exhibit 11,
Correct.
state that I received that photo in an email yesterday from the code enforcement office. Mr. Carter, do you recognize this photograph?
Yes, sir.
Does that photograph show approximately the same property?
Yes, sir. This was taken further back on South Royal Springs, again from inside the vehicle due to the pouring down rain. I'm not going to ruin a camera taking a picture.
But you took that picture.
I took this picture yesterday afternoon, which shows, again, the fire hydrant from a different perspective, from a different angle. It does show two stacks of mowed grasses and weeds. It shows also the telephone pole, which is visible in photograph number 10. This is a photograph of the same locations and same properties involved.
Okay. Thank you.
Mr. Price, any objection? Beyond, obviously, what we talked about, where you'll be able to present in your case on direct about what portion of this property belongs to the city versus yours. But any objection to this photo?
No, ma'am.
Thank you. Introduce number 11.
Mark also.
That'd be great, thank you. Oh, well, it didn't end.
And if you'll just indulge me and pull the citation again for that property, which I believe was citation number 225. This is the citation, the violation listed, is it the same on this property as it is on the last one? Are all the the violations listed in those 4 citations the same?
Yes, sir. The same verbiage appears in each of these 4 citations, which addresses the
And is it
Crestwood.
your opinion as code enforcement officer that the pictures in 10 and 11 constitute proof of the violations listed in that citation?
Yes, sir.
I'll introduce this as Exhibit 12 and state that I, again, downloaded this from the CityWorks system this morning, case 18226, with an address of 312 Lexington Avenue, and the date in the system for the photo is May 1st. Do you recognize that photo?
Yes, sir.
Did you take that photo?
Yes, sir. I took this photo yesterday afternoon prior to the rainstorm beginning. This was taken from outside the vehicle, standing on Lexington Avenue, looking at the rear.
Now, you said you took that yesterday, and I stated earlier that I pulled this from the system on May 1. Did I hand you the wrong photograph? No, sir, I don't believe I did.
No, sir, you did not. I was mistaken. This is an earlier photograph because you can see in this photograph, this is number 11, this is number 12. In this photograph, you can see a boat that is being stored on the back of a piece of property that belongs to Mr. Gant. And you cannot see that boat in yesterday's photograph. It was not visible. This is a photo taken from Lexington Avenue, looking towards Broadway, looking towards Garth School area.
Could you identify on the PVA map there which property, approximately where you're standing and which property you're looking at?
Yes, sir. If you're looking at the photograph directly as it's printed, not upside down, this will be the upper left section that is outlined in yellow that abuts Lexington Avenue.
Thank you.
Mr. Price, any objection to entering this photo as an exhibit? Exhibit number 12.
This is exhibit number 12 that shows a boat. Right?
Up about
Is exhibit 12, is this the one that shows the boat? Is that exhibit 12?
number 12, yes, sir.
And that's the same photo that you sent me on May the 1st, isn't it?
Yes, sir. It's May the 1st. Yes, sir.
And you sent me a black and white copy of it, right?
I print photos in black and white. Yes, sir. I do not have a color printer.
Right, so I mean, but
Okay.
it's the same photo you sent me, right?
Yes,
Mr.
sir.
Price, please remember, this is not time to cross-examine. Please address me and let me know if you have any objections.
No, ma'am.
Okay, thank you. This will be entered as exhibit 12.
All right, one final photo to enter. I'd ask this be marked as exhibit 13 and state that this was emailed to me yesterday by the code enforcement office. Mr. Carter, do you recognize that photo?
Yes, sir.
Did you take that photo?
Yes, sir. I did.
And when did you take that photo?
This one was taken yesterday afternoon, standing on Lexington Avenue, adjacent to some daylilies that were growing at the side. This is looking basically the same direction. The trees in the center, basically the center of this picture, are a little closer than the ones in number 12. This is of the same property that is at the rear of 167 Rucker and off of Lexington Avenue.
Thank you. So
And you cannot see a boat in this picture.
I'm looking approximately in the same direction in those two photographs.
Yes, sir.
Of the same property. And in your opinion, do those photos constitute evidence or proof of the violations alleged in citation 18226?
Yes, sir. There's no evidence in this photo number 12 of any, excuse me, not number 12, this would be number 13, of any tended vegetation in this area.
You're saying that between the first photo and the second photo, you don't see any evidence of there being any plants?
Of any mowing or any removal that I'm able to determine, no, sir.
Thank you.
Mr. Price, any objection to entering this photo, the boatless photo, as number 13?
And that was taken yesterday, 6:20, that's
Yes.
No, ma'am, am I correct? It was taken 6:20?
That is what he testified to, yes.
Thank you.
I'm going to ask that this be marked as Exhibit 14 and state that I downloaded this from our website this morning, which is our code of ordinance.
Mr. Price, any objection?
No, ma'am.
So enter 14.
Thank you. Now, I will also state that this is a portion, of course, of our 800-page code of ordinances.
Relevant portion?
Yes. if you could, there's a highlighted section there, if you could tell me if you recognize that.
Yes, sir, it's a partial section of the Georgetown Code of Ordinances, 4122.
Is that the same section that is cited in the 4 citations?
Yes, sir, which includes Property Maintenance Code 302.4, which specified being adopted by 41 and 122.
If you would turn to the second page and read that first highlighted section.
Under section 302.4A in definitions, untended, rank, or unmanaged vegetation means overgrown vegetation or vegetation in an unhealthful condition, which provides either a direct health hazard or a demonstrated breeding ground for fauna known to create a safety or health hazard, e.g. rodents, snakes, mosquitoes. Untended, rank, or unmanaged vegetation is a public nuisance.
Thank you. If I can see that for a moment, I have to make a third copy for myself. So I'll ask you again, looking at these 4 properties as a whole, is it your testimony that the properties contain untended, rank, or unmanaged vegetation?
Yes, sir, it is.
And you believe these properties meet this definition in the ordinance of untended, rank, or unmanaged vegetation?
Yes, sir, I do.
Okay. Have you, the ordinance mentions a direct health hazard or a demonstrated breeding ground for fauna known to create a safety or health hazard. Have you had occasion to visit this property before May 1st?
Yes, sir.
And you visited it a couple of times. You visited it on May 1st and you took the first round of photos.
Yes, sir.
And you visited it again when you took the photos yesterday.
Yes, sir.
In any of those visits to the property, have you ever directly witnessed any fauna that would create a safety or health hazard, including rodents, snakes, or mosquitoes?
Yes, sir.
Okay. In your time as a code enforcement officer, have you ever received any complaints from others, from surrounding property owners, of snakes, mosquitoes, or rodents?
Yes, sir.
Can you recall any specific times when you received those complaints?
Specific times, no, sir, not just off the top of my head, no.
How many approximate complaints would you say you had in the past? You've been a code enforcement officer for how many years?
Since 2013.
And since 2013, regarding any of these 4 properties, can you estimate the number of times you've received complaints regarding safety or health hazards, rodents, snakes, or mosquitoes?
From one specific resident on a yearly basis. From other property owners and other citizens. Probably a total of 6 or 7, 8, probably 8 between that time period.
I'm sorry, I couldn't hear that. Could you please speak up?
About 6 or 7 total from other property owners or citizens during that almost 5-year period.
Anytime you received a call or a complaint about those types of issues, would you have had occasion to go visit the property?
Yes, sir.
And when you visited the property, did you find the property to be in the same or substantially similar condition as shown in those photos?
Yes, sir.
So it's fair to say that in the past you have received complaints, and in response to those complaints, you have gone to the property and found the property to look substantially the same and to be in a substantially same condition as these photos show.
Yes, sir.
Okay, thank you. I'm going to point you to the second highlighted section and ask you to please read that.
Managed vegetation is defined as managed vegetation is vegetation utilized in a planned, designed yard or landscape, including natural landscaping with the intent to control, direct, and maintain the growth of natural vegetation according to its natural characteristics, and reduction, if not elimination, of fauna known to create a safety or health hazard. Managed vegetation is not subject to the 10-inch height restriction.
Thank you. So, tell me what your understanding is of the significance of this language.
There are certain plants, vegetation that's allowed to be used in landscaping that grow naturally. The ornamental purposes, things of that nature, you know, if I would say if a naturally occurring honeysuckle bush, whatever the official name of that plant is, was found to be growing on a property and it did not grow over a sidewalk or out into the street, it would be allowed to grow.
Would you characterize this language as an exception to the general 10-inch requirement?
As an exception, yes, sir.
An exception to the overall prohibition on rank untended vegetation?
Yes, sir.
This ordinance, this section of the ordinance talks about managed vegetation. It is a definition. It's in the definition section of managed vegetation. As you said, it speaks of the intent to control, direct, and maintain the growth of vegetation according to its natural characteristics. Is it your opinion that Mr. Price's properties are being managed in accordance with this definition?
No, sir, I don't believe they're being managed according to that definition.
Thank you. I believe that's all I have.
Thank you. Mr. Price, do you have cross-examination for Officer Carter?
Yes, ma'am.
Okay.
Get my water here, Mr. Price, I apologize.
Let's see here, I'm going to pull out this ordinance. In the first place, I should have objected to, or may I mean, let me stick to a cross-examination. William Carter, did you tell me last week when I came to your office to ask you about the legal basis for your citations? You remember I came to your office and you said that, and I said, what about ordinance 06-027? You told me it had been repealed. And you showed me or you wrote down for me on a piece of paper, you
Mr.
cited.
Price, please try to not testify. Please just try to ask him questions.
Okay, when you wrote down last week, you wrote down ordinance 16-, 0009, I believe. Isn't that the, isn't that what you wrote? Can you tell me the number of the ordinance you wrote down for me on a piece of paper,
Yes, sir.
please?
Yes, sir.
What was that ordinance number?
16-009.
Right. And you told me how to find, can you tell me where I would find that? I mean, what your direction to me was to do what?
That should be available on the city website or a copy from the city clerk's office.
Yeah, right. May I ask why you didn't challenge Attorney Hartley and say, when he handed you this a while ago, this is not the current ordinance, because this is an ordinance numbered 4-122. And that's a different ordinance from the one to which you referred me. May I ask you why you did not say to Attorney Hartley that the relevant ordinance is the same one to which you referred me?
The ordinance that is addressed on the notice of violation and subsequently on the citation that was issued for these properties stems from 4-121 and 4-122, which is this copy that says the city of Georgetown adopts property maintenance codes 302.4. The 16-009 ordinance was establishing the Code Enforcement Board, how it meets, how appeals are dealt with. It addresses a section of 302.4, unmanaged rank vegetation. It basically says the same thing.
Well, don't you think it's complicated, though? It makes it a complicated, I mean, I brought, and I'm going to submit it just as an exhibit, a copy of the ordinance to which you referred me, or an excerpt from it, the relevant excerpt. Would you agree with me that it's very confusing to have to deal with multiple citations of multiple ordinances, and would you agree with me that for the benefit of the hearing officer and any other possibly an appeals board, that by handing this ordinance to you, 4122, Attorney Hartley has made our job harder? And that he should, would you agree with me that that would make our job easier if he would hand you the ordinance to which you referred me?
I'm not sure if it's relevant or not. So we are referring to only the ordinance that is cited to in the citation. In this 16 section, is that the ordinance that created the hearing board, is what I'm understanding?
Yes, ma'am.
Which is not the ordinance that you are being cited under, correct? You're being cited under, did I hear 4? I don't have them in front of me, but you can see. I feel like you're,
If I may, I can clear it up pretty easily.
with that, I'm just trying to get to whether or not these questions are relevant.
Please go ahead, Attorney Hartley, if it's all right with you?
Ordinance section 4-122 has existed for a long time. And it has contained that precise language regarding the violations for some time. And when we modified the ordinance in 2016, we simply recodified that same exact language. That particular language has never been changed. And then we made additional changes to the overall Code Enforcement Board ordinance again in 2017. So that it might actually even show another, but the language has always been the same, has never changed. And it's 4-122, and the Property Maintenance Code section that it incorporates has the exact same language as 06027, to which Mr. Price refers. I have to disagree that it would be confusing. The citations themselves are all different, but the language has not changed in the last 12 years.
Is it a violation still under 4-122, or is it a violation under what he mentioned as 16? Just for my own knowledge.
Well, I mean, technically it would be both, because all 16 does is recodify
Okay.
the language.
So 4-122 still exists?
Correct.
Okay, sorry. Okay. I just wanted to clarify that so I can understand it better. Thank you. Mr. Price, you may continue.
What I've tried to do, if I may say so, Attorney Larmore, is to encourage the parties who cite me to make matters simpler by eliminating and not citing and not in their communication to me or here in these hearings outdated ordinances, which are basically he just said have been recodified, and I came to court, and I'm going to hand you a copy of an excerpt from the ordinance to which he referred me last week, which is 16-009. And it, all I can tell you is beware of the confusion that Attorney Hartley has created by introducing ordinance number 4122.
I appreciate that information, and you said you had did you have an exhibit which
Yes, ma'am. It's an excerpt from 16-009 is included in this paperwork I have for you, which I would like to enter as an exhibit, and I will say that I'll have a copy for the parties, Carter and Hartley, but they are not only partial copies. I've given them partial copies today because we had a problem with the copy machine last evening at the library. And I came to the clerk's office, tried to do it this morning. The problem was at the library was I ran out of money. But what I'm trying to say is I have full copies. I've given them partial copies. If you allow me later today, I will hand them full copies of the exhibit I want to hand you now.
Please just show Mr. Hartley the full copy, and if he would like to look through that full copy, he's welcome to. Yes, he has a right to.
And it's the same. I just apologize I don't have it in my hands to hand to them. But I went to the clerk's office early this morning, and I've got there's ink smudges. The ink cartridge.
I understand. It's fine. I have to show him a copy, so.
The copy machine, I'm saying, at the clerk's office wouldn't work, so I couldn't.
Mr. Hartley, would you like to go make a copy of that now, or?
I don't need to do that. I'm going to state on the record my general objection to relevance, but ask that he go ahead.
Okay.
You want to say it, Attorney? I mean, you want to give the same copy to the code officer?
You don't. You have to show it to opposing counsel, but you do not need to show it to Mr. Carter. So, if you'd like to approach and hand that to me, you're welcome to do so. I understand Mr. Hartley's objection, so I'll look at that and we'll determine whether or not it's relevant.
Are you saying that just all this paperwork is irrelevant?
No, I stated a general objection to the relevance to that document. I believe it may contain some relevant information, but I believe it also is going to contain quite a bit of irrelevant information. So I'm simply stating for the record my objection to the relevance of the document.
And I will.
Of the entire paperwork?
And I will make a determination as to his objection after I look at it. Mr. Hartley, it's my understanding that Mr. Price will proffer you a copy of that today.
Thank you.
So I'd ask that that happen. So you may approach Mr. Price. And you are proffering this as your exhibit.
This is my copy. This has got the ink smudges on it. I've got a better one for you. It
Okay.
doesn't have the ink smudges. And the reason those ink smudges are there is because the copy machine at the circuit clerk's office is one and it broke down.
So you are proffering this as Exhibit 1, and is this to rebut? It looks like there's some photos and stuff, so this is to rebut their photos, is what it looks like?
Yes, ma'am.
Okay. Did you have further questions for Officer Carter?
Yes, ma'am.
Okay, please continue with those.
Let's look at the, we're gonna have to look at, okay, let's take, you can look at 4122 if you want to, and I'll look at the one to which you referred me, the ordinance to which you referred me, 16-009. And let's look at what attorney, I'm going to ask you, Code Officer Carter, I'm going to refer to, for your convenience, I'll refer to, and for the convenience of this, of all parties, I'll refer to ordinance 4122, which in the highlighted section, the language is the same. I will say that I have to contradict Attorney Hartley. The language of all these ordinances is not exactly the same as 06-027, which he said, because 06-027 includes a repeal of the former 10-inch lawn mowing requirement. So I have to object to what Attorney Hartley said, that the language of all these ordinances is the same, because they're not. And you can verify that if you want to look at ordinance 06-027, you will find that the language is not the same. So, anyway, to get to these unintended, these highlighted sections that Attorney Hartley just showed you, Code Officer Carter, I've got a question here. It says, managed vegetation is well, you read it. Let me just ask you this. You read it to the parties assembled here. Managed vegetation, I'm going to read it, just managed vegetation is vegetation utilized with the intent to control, direct, and maintain the growth of the vegetation according to its natural characteristics and natural characteristics. I brought with me this morning a plant that I picked just about 30 feet off of Main Street over here on the alley on my way to this hearing. And if that plant had been managed as you want it, that is mowed down, would I be able to have that for breakfast?
Object to the relevance of the question.
That's the question.
Okay. I don't know if that's something he would have personal knowledge of. He's already testified he's not an expert. So your question is basically, if it was mowed down, you would not be able to eat it. I'm not sure that anyone would be able to know the answer to that.
Well, is that, may I rephrase it? Code Officer Carter, if you came over to my place, which you've done, and you told it just, they asked you, if you compare the two highlighted passages here, which of the two passages would allow me or any man, any proprietor in Georgetown to go on his property and harvest? This happens to be wild lettuce, one form of three forms of wild lettuce I have over there on my place. This is one of them. which I happen to say, as I said, I've got it right here off of Main Street, 30 feet off of Main Street. Which of these two, let's call it untended rank or unmanaged vegetation, if you refer to this as untended rank or unmanaged vegetation, in order to be able for me to have it, or anyone in Georgetown to enjoy it, to eat, would it have to be considered untended rank or unmanaged vegetation, or would it have to be considered managed vegetation utilized with intent to direct and maintain the growth of the natural vegetation according to its natural characteristics? Which of the two definitions, untended rank, unmanaged vegetation, or managed vegetation, is required for me to enjoy this wild lettuce in a salad?
I believe the intent of this is to guide residents on how they maintain their property. I don't know if this is gonna answer his question.
I understand. Just do the question.
If someone is intending to raise a crop of any kind for consumption, it's my understanding that that crop should be managed in such a way that it will be allowed to grow as good as possible, as large as possible, as prolific as possible, in a tended, take care of this, keep it weeded, let it grow, feed it, water it, be able to obtain as much usable end product from that plant as you can. That's my understanding of a managed garden or an area of managed vegetation, if you're talking about consumable type of vegetation. If you're talking about a yard, I don't recall anybody that would try to consume yard grass. It's possible. Yard grass, like go out and graze like a cow would graze in a field. It's possible that that could be done. I'm not saying it can't. But an unmanaged, if you have a plot of ground where you have a managed garden growing in a plot next to that that is allowed to grow naturally at will, I believe someone's gonna be able to harvest more usable provender, food, anything off of that managed tended garden than they would from the piece they just left alone and let grow wild. I don't know if that answered your question, but that's my take, that's my observation on these two sections. One of which is a tended location, a managed garden, taking care of this, feeding it, watering it, then the other is being an unmanaged section. I hope that answered your question.
May I ask you another question?
Yes, sir.
Do you raise a garden?
Do I raise a garden?
Mhm.
No longer, no, sir. I don't have property any longer.
Did you ever raise a garden?
Yes, sir, I did.
Vegetables?
Yes, sir.
How many hours a week did you put in on it?
Four or 5 hours a night,
Mhm.
5 or 6 days a week, 30 hours, about 30 hours a week.
Mhm. And that was in addition to, were you working a job at the time?
Yes, sir.
Yeah, so you were raising a garden in your spare time, right?
Basically, yes, sir.
Yeah. In the paperwork, have you ever heard of a book called Eat the Weeds?
I have not, no, sir.
If I had showed you a book, as a matter of fact, I gave a copy of it to, or I loaned a copy of it to Attorney Hartley's office. If you were to, someone would put that book in front of you, and you read the title, Eat the Weeds, what do you think that book would be about?
Trying to educate you on which plants that the common person would classify as a weed that would be edible. I've eaten wild dandelions. You can cook them just like you can kale greens or anything else, or spinach, and it's good.
So what kind of salad vegetables did you raise in your garden?
Salad vegetables?
I think we've somewhat gone astray of relevance, so I do kind of want to limit it back to, I do understand the questions about, you know, recognizing, what wild, plants could be used as food, but I do think we've kind of gone somewhat astray of our original.
Well, okay, let me ask you this, Code Officer Carter. If you had an option, let's say you're working so much that you don't have time to raise a garden, and you came home and you saw dandelion growing in your yard, would you eat it? If you were hungry?
Object to the relevance of that question.
I'm going to sustain that objection. I think that we do need to limit it down to this situation and your plans and, you know, what your yard looked like, may have been done, may not have been done, what those plants, you know, their current state, what they may require, as far as you're able to testify to that, or, you know, obviously this
All right,
witness may not be, but when we're doing your case on chief.
Let me pull this photograph out here. I'm going to show him this photograph.
Exhibit 11.
That's a photograph you took yesterday.
Yes, sir.
Can I show that to the hearing officer?
Yes, sir.
And could you, let me find one. Let's see that again, please.
I have the same one.
Oh, you got
That's,
the same one, yeah, right. All right, this one was taken, is this the one you took on May the 1st?
that clearly shows the fire hydrant? Yes, sir.
So this is the one, you compare these two,
Mm-hmm.
you see that, you see a difference?
It's not to ask me questions, so.
Well, okay, do you see a difference, in the two?
Yes, sir.
What's the difference?
Number 10 is taken close to the fire hydrant, which shows growth behind that on property. The property on number 10, on the one in your right hand, number 10 shows a closely mowed section with a fire hydrant. that closely mowed section of property is city property.
Some of it is, some of it's my property that the neighbor mowed.
The overgrowth behind that section are pieces of section, the top two section pieces here on number 5. That's where they butt up, those two properties butt up and join. That shows the area behind that with overgrowth.
Yeah, but what would you call this? Can I ask you, what do you call that right there, that object in the photograph?
Those two mounds of grass,
Mounds of grass?
Yes, sir.
Is that what you call them?
that's what I would call them, yeah. That's where,
Mm-hmm. And so. do
Someone
those
has
two-
cut
do
that.
those two mounds of grass appear in this photograph?
no, sir, they do not.
Wonder why not?
Is that a question for him?
Well, can I ask you why, this one was taken May the 1st, this one was taken June the 20th.
Yes, sir.
And so sometime between May the 1st and June 20th, somebody put, what you call it, a mountain of grass?
Two mounds of grass, yes,
Two
sir.
mounds of grass. Somebody put that there.
I
Right.
presume so, yes, sir.
Yeah. We should show this to Attorney Harvey,
Yes, thank you.
all right? If somebody, let me ask you this, Attorney, Code Officer Carter. Does this appear, are the two different heights of vegetation here? Does this indicate mowing right here to you? You see here in the foreground, you have vegetation that looks like it may be 4 or 5, maybe 6 inches tall. as
Yes, sir.
Compared to surrounding vegetation, which, as you said a while ago, is as tall as you are.
Pretty much, yes, sir.
So that's, does this suggest to you that somebody has mowed here?
Somebody's cut something down, yes, sir.
Yeah, right, and then, what do you suppose somebody, if somebody wanted to use the vegetation that they mowed and make hay out of it, would it make sense to mow it on May the 1st? Or would it make sense to wait until June the 20th when when the grass has grown to a height of, like you said a while ago, it may be as tall as a man?
Yeah, if it's a farming operation and somebody's trying to grow hay, then you want it as tall as possible.
That's right, and is there any reason why under the ordinance, 4122, does ordinance 4122, it requires, am I correct in that ordinance 4122 requires that unmanaged vegetation not exceed a height of 10 inches?
Unmanaged vegetation?
Right. Let's take a look at the ordinance.
It says managed vegetation. The presence of untended, rank, or unmanaged vegetation exceeding 10 inches in height is a violation of that section. Managed vegetation is not subject to the 10-inch height restriction.
Right. You're reading that from 4122, correct?
Correct.
Could you repeat that,
Well, it's
please?
302.4 in 4122, yes, sir.
Well, are you reading the highlighted section that Attorney Hartley gave?
On
you
page 286.1 at the bottom, the one you're pointing to, yes, sir, that's what I read.
286.1.
Yes, sir.
At the bottom, you're right. Could you repeat the final sentence there in the second highlighted paragraph?
The second highlighted paragraph
Final sentence.
defines managed vegetation. It says managed vegetation is not subject to the 10-inch height restriction.
Right. But would you consider mowing of the grass, and would you not consider this management that, let's say in these photographs, with the fact that someone would go there and mow this part of it, and mow this part of it, would that constitute management?
Someone started to, yes, sir. I would say someone started to mow that.
Yeah, and the date that, if a person, what day does grass mature? Say, or hay, or what time, what date does, in the annual sequence of the seasons and vegetative growth, at what seasons, or what part of the year does somebody begin to manage grass for hay?
I would say that I don't know that this expert has been qualified to be or this witness has been qualified to be an expert in kind of agricultural systems to be able to answer
Well-
to give expert testimony.
So you don't have any experience with hay? I thought you told me you used to work on a farm.
I've worked on a farm, yes, sir.
Did you manage hay?
I did not manage hay, no, sir.
Well, have you seen the current News Graphic newspaper?
No, sir.
You acquainted with a farmer here in Scott County named Stephen Smith?
I don't believe so.
And so you haven't seen his picture on the front page of the News Graphic, the current News Graphic?
No, sir.
Well,
Mr. Price, Mr. Price, please recall that you'll be able to testify, but do you have any specific cross-examination for Mr. Carter regarding these questions or the particular, circumstances that led him to filing these citations? But I think that anything as to experts or, his own personal life, I don't know about the relevancy. He hasn't been qualified as an expert. And then, his personal life, in as much as it does not relate to this case, I'm not sure that it's relevant. But do you have any more specific questions relating to him, relating to the pictures or the circumstances that led to the filing of these citations? If not, then we can move on and perhaps, after seeing if there's any redirect, allow you to present your case in chief. But certainly, if you have any other, cross-examination questions, then you're welcome to answer those.
Attorney Hart asked you if you'd seen any fauna in visiting my place. Fauna known to be, what language? Fauna known to create a safety or health hazard. Could you describe it, such fauna that you saw on my property?
Basically, it's vegetation that's in excess of 10 inches high. Anything that,
What?
vegetation that's in excess of 10 inches high
Well, what is-
would
what
be a
is-
violation.
Excuse me, what is fauna? Do you know what fauna are?
No, sir. I don't know the whole definition of that, no, sir.
May I ask you, Attorney Longmore, do you know what fauna are?
You may not ask me. I take in evidence and will issue a order.
Okay, well, let me, may I, so let me ask you again. Could you please read, if you don't mind, Officer Carter, could you please read the first sentence there in the first, yeah, you got it, in the first highlighted section?
It says untended, rank, or unmanaged vegetation. Overgrown vegetation or vegetation in an unhealthful condition which provides either a direct health hazard or a demonstrated breeding ground for fauna known to create a safety or health hazard, e.g. rodents, snakes, or mosquitoes.
So what are fauna?
I would presume that it means some type of grasses,
Some kind of what?
some type of grasses, plants,
Well,
vegetation.
Did you just, did Attorney Harley just ask you, when you came to my place, did you see any fauna? And what was your response?
He may have. I don't recall if he did. it's
Well,
possible.
He said you visited my place a number of times over all the years that you've been code enforcement officer, and he asked you if you had seen any fauna.
Object to that.
Is that wrong?
Object to the characterization of my question. The record will speak for itself.
Well, so for the benefit of the court, in your opinion, the word fauna means grasses?
Grasses, vegetation, growth. Yes, sir.
So I've heard the definition, I'll be able to kind of, so basically it sounds like from what Officer Carter has read, that it's fauna that either encourages or also includes the, basically, pests, which include rats, mosquitoes, things such as that, is from what Mr. Carter read. I think.
Yes, ma'am.
Yes, so that was how it was defined under the statute, so I'll look at that, and then I do recall Mr. Carter's testimony about having observed, I think, animals which would meet the definition under the code over the last few years on your property, was what I recall from his testimony.
Yes, ma'am.
So let's replace the word animal, fauna with animal. What animals have you seen on my property in your visit?
There's been squirrels. There's been terrapins. There's been cats. There's been mice. Snakes.
What kind of snake?
I didn't bother to ask them. I don't know what kind of snake it was, sir.
How many snakes have you seen?
Well, I don't know that he had finished his original answer. He was, I think, listing out.
Excuse me.
Had you finished that, or did you need more time?
itemizing.
Mosquitoes, we've had ticks, birds.
Birds?
I mean, just normal outside animals that would,
Okay. Did you have anything else to include on that list, or was that list complete as far as you recall at this time?
would say that's probably
Okay.
a pretty complete.
Okay.
So which of those animals are known to create a safety, a health hazard?
I think he is referring to the list as part of the code, if you need to refer to that.
I don't think the code specifically lists ticks, but that's a common occurring thing in tall grasses. Mosquitoes, definitely, we're bitten repeatedly.
Mosquitoes, I'm sorry, definitely.
We were bitten repeatedly by mosquitoes there.
When you said we, who was, were you?
Myself and anybody else that was there.
You were accompanied by someone else?
Yes, sir. On numerous occasions, yes, sir.
Some of your personnel? Some of your colleagues?
Some of the co-workers, some of the code enforcement office, some of the public works officials. Yes, sir.
Mhm. And so what, their complaints about hazardous animals included what now? Which ones? Mosquitoes, others?
Ticks.
Others?
I don't think the birds bothered anybody, but
No. So the hazardous animals that you recall that were subject of complaint were ticks and mosquitoes?
when I was present on the property were those two, yes, sir.
Yeah.
There have been complaints of snakes, yes.
And were the snakes, how is this every snake a hazard? Every snake a safety or health hazard? Or just poisonous snakes?
In general, in my opinion, if someone is afraid of a snake, then it is a hazard, yes, sir. Whether it is poisonous or not.
Well, should a person be afraid of a snake if it's not hazardous?
I think we've kind of gone I've heard the list, and I'm actually the one who will make the determination out of the list and referring to the code when I make my orders as to what is, hazardous or a pest or not. But I have heard the list, and will refer to that as to what I think may constitute, but I do understand the question. So if we can.
Let's see.
And I do feel as though I should make everyone aware that it is about 11:10 now, and I will need to leave here by about 11:45.
Okay, well, so I don't want to monopolize everybody's time any more than I already have. I guess I have an opportunity to respond to what we've just witnessed.
Yes, are you finished with your cross-examination?
I will finish it just to
Okay.
accommodate everybody.
Mr. Hartley, did you have any redirect?
I'd just like to clear for the record, when we refer to 4-122, that is the Code of Ordinances section. So if you go to our Code of Ordinances, it's just like going to a KRS statute. You go to KRS 65.3358, that's a statute. And those statutes and those ordinances, those code sections are amended by ordinances. Ordinance 06027 amends section 4-122. And Ordinance 16-009 amends section 4-122. So it remains the same codified section in our ordinance, in our code of ordinances, but each individual ordinance may modify the same section. I'd just like to state that clarification for the record.
I think that it sounds like, Mr. Carter, like you'll be able to step down now. You can hand me those, please. And actually, Mr. Carter, if you do not mind, would it be possible on the photos for you to write down the property address on the back? It sounds like you may be the best one to know.
Yes, ma'am.
And you can just take those down with you, and then,
Return them?
yes, thank
Yes,
you.
ma'am.
You have a pen, it looked like. Now, and Mr. Price, I'm having Officer Carter write down the addresses on the back of the photos, just so I know what address each photo belongs to, and you'll be able to look at those and review those to make a determination that those are the correct addresses before I take them, okay? Now, Mr. Hartley, does your case rest?
It does.
Okay. Mr. Price, if you'd like to present your case?
I think you left these here.
You can just do it.
And may I call witnesses?
You may.
May I call Attorney Hartley?
No, he is opposing party, so I,
Okay, so I can call Attorney Hartley. May I call Code Officer Carter?
well, you just cross-examined him, so is there something more on direct that you would need? Because you did just have an opportunity to cross-examine him. So was there something more on direct that would be beyond the scope of the cross-examination?
Yes, ma'am. I'm sure there would be.
Okay, well, yes.
I mean,
you-
if I'm allowed to call witnesses, he's the only option I have, unless I were to call some of these other people.
Okay,
But he's their boss, and I think he could speak I don't know.
You
I
can
mean,
call Officer Carter, but do please try to restrict it to, new questions. We're not going to go over what we've already gone over, and we're also going to try to stay within, relevance as to the current situation. So, but you may call Officer Carter. Officer Carter, if you may return. And just bring the exhibits up with you, please. We meet here again. And please recall that you are under oath.
Yes, ma'am.
Thank you. Okay. You may ask, Mr. Price.
Thank you. Code Officer Carter, do your duties include enforcement of noise nuisances? Reports of noise nuisance?
Objection relevant to that?
Is this relating in some way to this, and how is that related to this?
Because I'm looking here at the copy of the Scott County zoning ordinance, which includes a noise prohibition. It says, "Home occupation shall not generate noise
Okay.
or atmospheric pollution."
I'm not disagreeing with that. I don't have that in front of me, but we are not considering a noise order. We're not considering a citation regarding noise today. You do not have filed one filed against you, and that is not appropriate for today's hearing.
Well, how, well, let me put it another way then. May I ask you, Attorney Code Officer Carter, does growing grass make any noise?
Objection irrelevant.
I'll let him ask that and answer that.
Does the grass growing itself make noise,
Yeah.
or does the act of allowing grass to grow make noise?
Well, does either make any noise?
The act of allowing grass to grow, I don't believe makes any noise, and I'm not able to perceive grass growing as making noise.
Right. So no, grass growing does not make any noise. Does managing grass with machinery make noise?
Objection irrelevant.
I'm going to sustain that objection. Once again, we're not here on any kind of violation of a noise ordinance. We are here on citations, as far as I recalled when I reviewed those, as to the height of the grass and I think some kind of allegations of unmanaged vegetation. So we do not have any violations against you of a noise ordinance. I do understand where you're trying to go, that managing the grass may cause noise, and certainly that if you received such a violation, you would be able to use that as a defense that you were managing the vegetation, but that's not what we're here for today, and I don't believe that's relevant to today's proceeding. So I will sustain Mr. Hartley's objection, ask that you move on to a different thread.
Code Officer Carter, are you acquainted with Federal Law 16 U.S. Code, Section 2105?
Not off the top of my head, no, sir.
If I were to tell you that it permits urban forestry and complementary ground covers to urban forestry, would that impact the work you do?
Gonna object on foundation ground.
I would sustain that. He's testified he's not familiar with it. He does not have a copy of it, and I don't think that he is appropriate person to be able to testify to that.
Well, if federal and state law and our local ordinance 06 or 16-009 permit natural landscaping and/or urban forestry,
Objection.
may I finish the sentence?
I was gonna say, he can finish the sentence and then we'll,
If Georgetown ordinance 16-009, KRS 149.336, and 16 U.S. Code Section 2105, let's say that they permit and encourage, and in the case of the federal law, even offer funding for urban forestry, including complementary ground covers, what would be, in your opinion, the meaning of the term complementary ground cover in relation to urban forestry? What would be, well, let's say, what in your opinion is urban forestry?
Object on the foundation ground, and it calls for speculation.
I would sustain on both those because we have the code in front of us as to what I think you're being cited under. I think you are citing different codes that we do not have in front of us, and we do not have copies of those. As well as I would sustain also on the speculation, asking for an opinion.
Okay, you do have ordinance 16-009 in front of you.
I don't know if,
May I ask, you do, Attorney Longmore?
oh, I don't have any of them yet. He has all, but as far as I'm aware, it was 4-122 that was entered in.
Okay,
as
well,
exhibit.
let's rely on
That
it
was
then.
14.
Yeah, right, you have it in front of you. What's the meaning there of natural landscaping?
Is this one of the questions that I feel like we may have already read this definition. If he gets to it and we already have, then we will need to move on, because I know we had multiple questions regarding.
Okay, well, I'll tell you, we're getting short on time.
Uh-huh.
Okay, well, let me just present, let's dispense with any examination.
Are you
Witness-
wanting to close your case in chief and move to closing for both parties?
Are you approaching, are you suggesting we do that to say, because you're,
I can't, I'm not, suggesting anything. You had said you want to move on to, so do you still have questions for Officer Carter?
I have a lot of questions for him, but you say we don't have time. I mean, it's what,
I'm trying to figure out if they're relevant, because we have gone over this section multiple times and we've read it out loud. So we're not gonna keep
yeah, but
reading it
the
out loud.
word natural landscaping has not occurred until I just mentioned it a minute ago.
Okay, if there is a new section, then Officer Carter, please proceed, Mr. Price.
What is natural landscaping? You find it on the first page of the paperwork that Attorney Hartley handed you in the last sentence.
It's included in verbiage under legislative purpose, which says the city acknowledges the desirability of permitting and encouraging the preservation and restoration of natural plant communities in urban, suburban, and rural areas. It further acknowledges the need to enjoy and benefit from the variety, beauty, and values of natural landscaping, including freedom from toxic chemicals, and seeks to guarantee its citizens the freedom to employ natural landscaping as a viable and desirable alternative to conventional modes of landscaping.
Right. And what is a conventional mode of landscaping?
I would presume having managed areas. I don't do landscaping, though.
Well, we're not talking about, we're talking about as an alternative. And let me ask you, you sent me a citation. Did you send me a citation telling me that the vegetation on my property is not allowed to exceed 10 inches?
Yes, sir.
Okay, if you turn over here to the second page, and you look under managed vegetation, in the next to the last paragraph, would you mind reading the last sentence?
The last sentence says, managed vegetation is not subject to the 10-inch height restriction.
Right, and you just told me that you sent me, that there's a citation you sent me that says that my vegetation is not allowed to exceed 10 inches, right?
Correct. It's unmanaged vegetation.
Yeah, and so you're saying that the plants on my property, if you send me a notice saying they can't exceed 10 inches, then in your opinion, that vegetation is unmanaged, right?
Correct.
Because if it were managed, I would not be subject to the 10-inch.
If it was managed, it would be less than 10 inches.
If it were, let's say it again, you want to read the last sentence again, please?
Managed vegetation is not subject to 10 inches height restriction.
Right. So would you agree, would you, if I say to you that I'm managing my vegetation for wild edible plants, would that, so, and they have to grow to whatever height, I've got wild lettuce over there that's 8 feet now, would you say that that's not permitted?
You're saying this is wild lettuce that grows
Yeah,
naturally?
A species like this, except it's, right now it's about 8 feet tall, some of it. But are you saying that I'm not allowed to manage the wild lettuce? The very definition is that to maintain the growth of natural vegetation according to its natural characteristics. Are you telling me that I'm not allowed to do that even though this ordinance says that I can?
I don't understand your question.
Did you send me a notice saying that all the vegetation on my property is not allowed to exceed 10 inches?
Yes, sir.
What if the natural growth, the natural vegetation, the natural characteristics of wild lettuce is to grow to 12 or 15 feet? Not this variety, not this subspecies, but there is a subspecies of wild lettuce that reaches a height of 12 feet. Would you consider that unmanaged simply because it grows to 12 feet high?
You just said you don't have that specific
No, I'm asking you a
species or
question,
whatever it is.
Mr. Carter. If I have a plant on my property that grows to 12 feet tall, that is its natural characteristic to reach 12 foot tall. Poke, for example, grows to be 8 feet tall. Poke greens, poke weed. Chicory grows 4 feet tall. Are you saying that in spite of this language here that allows plants to grow according to their natural characteristics, that all plants that exceed 10 inches, if they grow, in other words, are you saying to me, and does your citation impose upon me your idea that any plant in excess of 10 inches is prohibited?
If you plant something and tend it in such a way to allow it to grow to its full potential, and you tend that and you manage that, then that's managed vegetation. You're growing a garden is what you do. But if you just let things grow as they choose at will without any control or assistance or not sure the word I want to use.
And I think that we have actually gone down this road already in your original cross. Because I think we've had already discussion on the managed versus unmanaged with this witness. So I do understand what you're
Okay,
going for.
all right, well, let's,
I understand what you're going for, and I've taken note of it.
Thank
But I
you.
do think that we have gone down this road before
All right.
and need to move on from it.
Okay, well, how much time do we have?
About 10 minutes, which will include the final closing statements from both parties.
Well, I better make my closing statement then.
Okay. Actually, so are you closing your case on chief?
I'm sorry?
Do you have any other witnesses?
No, ma'am.
Okay. Do you have any other exhibits? I have entered number 1. I do think there are some things that are relevant and some things that aren't, but I will review it. So I've entered your exhibit number 1, which is
And
this
I,
pack.
as I
And-
said, I intend to bring 4 copies today to him and to him.
Okay, and I think that that is fine with Mr. Hartley. So do you have any other exhibits?
No, ma'am.
Do you have any other questions for this witness?
No, ma'am.
Okay. Officer Carter, thank you. You are excused, and I will wait to get from you those pictures. So actually, I think, Mr. Hartley, if I recall, then you get to come up first on your closing statement, and then Mr. Price can conclude.
I believe that the city has met its burden in showing that the 4 properties owned by Mr. Price that are included in the 4 citations meet the criteria in the ordinance. There is a violation. There is rank, untended, unmanaged vegetation. I believe we've provided ample evidence of that, and I believe we have provided substantial evidence that the broad vegetative growth, the amount of vegetative growth, the density of the growth is sufficient to show that the properties as a whole are not managed vegetation. Do not dispute the fact that Mr. Price finds vegetation on his property that he finds useful. But I do believe the city has established by substantial evidence that the properties as a whole are not being managed and are therefore not entitled to the exemption under the ordinance for managed vegetation. I also should state that due to the nature of vegetation, this is something that occurs year after year, multiple times a year, and we are therefore requesting, as part of the hearing officer's order, that so long as the nature of the vegetative growth remains the same, and so long as the property remains in Mr. Price's hands, that we ask the hearing officer for a standing order that such vegetative growth, that the violations remain abated, the property remain managed. Our ordinance contains a requirement or an allowance to homeowners that anytime they appeal a citation of a violation, that we cease all abatement. And in this case, Mr. Price always appeals his citations for tall grass, and I believe once we have established on the record that the vegetative growth on his property in general constitutes a violation of our ordinance, that we should not have to come back before this hearing officer and the code enforcement office every single time before we abate. So I asked the hearing officer to issue orders that there are violations on the property that should be remedied within 5 calendar days to the satisfaction of the city of Georgetown, that if the respondent fails to do so within 5 days, the city is authorized to abate those violations, and Mr. Price should receive a fine of $500, which is authorized under the ordinance, and for that standing order. And I would actually like to tender to the hearing officer, and with copy to Mr. Price, a proposed final order containing the findings of fact and conclusions.
And I'm actually going to ask both sides if they would like to send me proposed orders, but I'm going to have them send it electronically. So I will give my administrative assistant's email address to each party. I'll write that down at the conclusion so that both parties can send me proposed orders. I will have to check the code as to standing orders. I'm not sure. I will have to check the code as to whether or not I am able to enter standing orders or not after I make the determination on the case in chief. I'm not sure about standing orders, if that is something I'm even able to do if I rule, and depending on how I rule. So I will do a little bit more research into the code and reread it. Do you have any, do you have any
I have
other?
nothing further.
Yes. Okay, Mr. Price, do you have a closing?
Attorney Longmore, I'm going to, I don't enjoy having to appeal anything. I don't enjoy litigating. And you can look at the photographs you have there, and the photographs I showed you already. You saw this photograph right here indicates that I am mowing. I began on Sunday, the 17th of June, to mow the grass, the goldenrod, and various other weeds, some of which I don't know the names, for structural hay and possibly to sell the hay to somebody that has livestock. But you can't begin to manage hay until it matures in midsummer. And the reason I mentioned the news graphic and the picture of Stephen Smith, on the front of the current news graphic is a big picture of Stephen Smith, who happens to sit on the Zoning and Planning Commission. He's standing beside a big roll bale of hay. It's on the front page of the current news graphic. The reason the newspaper made that photograph of Stephen Smith is because it's hay season. He could have come to my place and made a picture of me. As of last Sunday, I've been out there every day mowing my place for hay. And you can't begin mowing hay until the grass matures, which is midsummer. And I propose to you, in this letter, I'm going to read this to you, and as a counter proposal to Attorney Hartlett's request for an order. I'm gonna, this says here, the volunteer crops I have are propagated by birds, wind, squirrels, and don't align themselves in neat rows that can be hastily weeded and between mowed with motorized machinery. If you would allow time for my grasses, goldenrod, and other fibrous weeds to mature, I can harvest them for structural hay from among the more desirable volunteer food and timber plants with hand tools. Scythe, there's a picture of the scythe I used, a picture of all the hand tools, you got them. Scythe, rake, and fork. That is a scythe, a rake, and a hay fork. As I began to harvest on Sunday, 6/17/18, that's this past Sunday. I began to harvest my hay this past Sunday. Such harvest and storage with hand tools making no noise in compliance with the Scott County zoning ordinance. Scott County zoning ordinance says no home occupation shall emit noise or atmospheric pollution. I'm using the hand tools in order to comply. They want me to mow with it. There's no way to manage it within 5 days without using machinery. That machinery will defy the zoning ordinance requirement for no noise. I'm willing to do it, able to do it with hand tools. Hand tools takes time. Such harvest and storage with hand tools takes time, but I could have my entire 2.5 acres harvested for hay by early or mid-August if you would allow me. With such management for hay, in addition to that for all the other crops, which you've seen that I've mowed around, you can see that in the photographs, your code enforcement officer will have to concede that my managed vegetation as defined by your ordinance 16-009, page 31, paragraph 5, is not subject to the 10-inch height limitation and thus to the mowing requirement imposed upon me by your code enforcement officer in his notice of violation he delivered to me on or about 5/1/18. Page 31 in ordinance 16-009 defines the definition of managed vegetation includes reference to fauna known to create a safety or health hazard. The only fauna on my place that could be considered hazardous are field mice, which I hardly ever see because of feral house cats. He said he saw cats. Feral house cats regularly range on my place. They control any animals that might possibly be considered hazardous, the only one of which could be mice. Snakes are not hazardous because all we have around here is garter snakes. Mice could be hazardous to our crops, and I'm thankful that I have these feral house cats who roam my property and who apparently eat them because I never see a mouse. Any hazardous fauna would be subject to my immediate control due to the threat they would pose to my crops. I'm not controlling any hazardous fauna because there are no hazardous fauna. Herewith are photographs. This is a letter I've written to Mayor Prather, but it's in your exhibit. Herewith are photographs I made of my Royal Springs Avenue hayfields from 6/13 through 6/20/18. I'm sorry, I said I began on 6/17. I began, no, that's right, yeah, 6/17. 6/13 through 18, 6/13/18 through 6/20/18, which show process of my mowing with a scythe. You can see the photos of the scythe mowing around desirable, economically valuable volunteer plants, most of which plants in the photos happen to be parsnip. But there are, and the photograph further shows the process of drying the hay. You have to let it lay and dry, especially now that it's rained. I'll have to go home and turn it and let it dry, gather it, and stack it for storage. And what I'm going to reiterate this proposal. If you would allow me to continue to manage my property, I couldn't begin mowing it before it matured. And last summer, I paid a man $350 to come and mow it in late or mid-June. 3 days later, the town came over there, and Bruin, the public works man, said that's no good. I paid a man $350 to mow the hay. Bruin comes along and says, no, that's no good. It doesn't look right. So we're going to finish mow it. I didn't even get to rake the hay and manage the hay because the town said it didn't look right. But aesthetic judgments are not allowed under ordinance 16-009. And the fact that it may not look right does not is not a reason that I can't manage my property for hay. And the fact that if I do manage for hay, every square foot of my property will be managed. Because what I'm not managing for hay
Mrs.
is,
Price, I think your closing's gone on for about 7 minutes, so we're gonna need to wrap this up. It's 11:44, so I think you've gone on for approximately about 7 minutes now for your closing. So we have about 3 minutes per closing, so we've kind of gone
I
beyond
didn't know
that.
that, I didn't know that, so now I know that.
Okay.
So how much time do I have?
Well, I have about a minute till I need to go, so.
Okay, all right, so,
But I will say, obviously, I have not prejudged this, and I will review all the evidence and issue an order. As I said, both parties are welcome to submit proposed orders to my office via email to my administrative assistant's email address, which I will provide. I would also note, I know that we had a previous hearing together, and I'd had to issue that letter. Please remember that we accept no other evidence after now. After right now, no other evidence has been admitted, so please do not send anything besides a proposed order to my office via email. Same with Mr. Hartley. I would also, I'm sure, make him aware of that as well, and I will issue an order as quickly as I can. Of course, I always encourage the parties, and especially in this type of situation, if you would like to continue mowing, and perhaps you two can have a meeting of the minds, and you're welcome to jointly send me an order. I would always be happy to review that, and if it seems reasonable and it's from both parties, I see no reason that couldn't be acceptable. But as to now, I would just accept proposed orders from both parties, and I will review those and make my own orders.
may I ask you a question?
Sure.
Because I'm not, I don't have access to a computer, may I tender my agreed, or maybe an agreed order or proposed order, bring a paper copy to your office?
I would really prefer them by email. You can do a paper copy, but it's obviously gonna be, it's a little more difficult, so I prefer them by email, but if you need to drop off a paper copy, you're welcome to do so.
Well, I don't even know, I don't know how to send an
Yes,
email.
you are welcome to drop off a paper copy to my administrative assistant, understanding that it is only a proposed order.
Right. And
Okay.
are you saying that that Attorney Hartley and I could meet and maybe draft an agreed order? That's what you said, is that not?
That is up to Mr. Hartley as to whether or not he wants to meet with you, but as in any other type of case, if the parties reach an agreement, then I would be happy to see that, but that would be up to Mr. Hartley as to whether or not he would want to.
Okay, well, I'm going to read here again. Such harvest and storage with hand tools takes time, but I could have my entire 2.5 acres harvested for hay, except for the beneficial plants, which I'm going to leave intact by early or to mid-August, if you would allow me.
Okay. I understand. I made note of that on my notes. And then, I don't know if that's in here, but I made note of it on my notes. So,
And
I
I said that
appreciate,
for Attorney Hartley's benefit.
okay. Well, I think that no other evidence being presented, parties haven't been satisfied, that this hearing is adjourned for today. Mr. Hartley, do you need my administrative assistant's email